I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Sunday. Happy Super Bowl Sunday. If you guys are watching the game tonight, be safe. Don't drink and drive. You don't want to end up on my channel. I know I say that every weekend, but yeah, don't do it tonight. Anyways, how's everybody doing? Happy Sunday. I see the chat rolling. Hope everybody's well. Good news. Just confirmed everything with Judge Slavin for tomorrow night. So it is green lit. We're doing it. Hope to see you guys all there. After this live, I'll be finalizing all the details of the video and everything. So I'll be sending out that link so everyone can get prepared. All right. Let's see. What else do I have to say? Not a lot. These clips I have today are from my vault. A little bit older. I mean, not terribly old. They're all from January, though. So just kind of trying to clean out the folder. And, it's Sunday. Not a lot of court going on. But before I hit that play button, you already know what to do. What is it? Like and subscribe. Do your jump kick backflips. And if you love the video and you want to drop a little tip, my link tree is in the description. Let's go.
All right, what are we doing?
Your Honor, we are going to be requesting an adjournment. I received information from Mr. Riaz that Ms. Roper has been accepted into 14B district court, and I understand there is a bond violation that Mr.
Yes,
Gannat-
there is.
Okay, and so I sent Ms. Roper.
All right, just a little background on her. You know what? Did I play this clip already? I played the clip of her going to jail. This is the clip before that. And I remember I said I was looking for it. Why does it sound like I've already said this before? I feel like I've already said this exact same thing. I was looking for this clip. I couldn't find it. Then I found it. I don't know. I just got a deja vu moment. Maybe played this already. All right, let's go. But yeah, this is the clip before she went to jail. So she doesn't go to jail in this clip, but she gets warned.
Similar to Mr. Klein, Mr.
Simon.
Thank you. It's been a long day. Over to community corrections. She was unable to test.
Been here for a minute.
I understand.
Okay.
I was here earlier today, Joe. Joe. See, anyways, she went over and was not allowed to test because she does not have a photo ID. Further, Ms. Roper has provided me, and I provided to Grace, who verified.
It's broke. But go ahead, go ahead.
Thank you.
All right.
Okay. A documentation that my client was in the hospital, University of Michigan psych ward for a period of time. That's why she was unable to go to community corrections. She also.
What period in time was that?
That was between approximately December 26th and 28th.
Okay.
She was released from the Washington County Jail, I believe, on the 22nd of December.
I went to
23rd.
both hospitals, both ERs, actually, not just the second one ER.
She also went to the ER again for a seizure that she had due to shingles, if I'm not mistaken. Is that correct?
And then staples me. About 6 staples in my head right now.
Because during her
Seizure
seizure,
and-
she fell.
Okay.
So doesn't excuse why she didn't go there when she was available, but it
Okay, if I
Explain.
grant you adjournment, how are we gonna get her tested if she doesn't have an ID?
No, I went over and asked, and they said I could have a copy of my ID, which community mental health has. So I just have to
Okay.
get that from my caseworker, and I can use that. And then I have to try and find $12, but other than that.
All right,
So-
I'm gonna indicate no more missed tests.
Yes, sir.
I'll have her bond continued. How long an adjournment did you need?
I think probably a couple of weeks to get her there over and show also a history of testing.
And there's no objection from the people on that.
No objection to the adjournment request. It's understood that we're gonna do a plea to the 14B drug court. I mean, I'm obviously a little upset about the fact that she didn't have the ability to have an ID available to do community.
Yeah, I
I threw
know.
it away when I was in jail, so.
Okay.
Well,
Don't interrupt.
it's more of the fact that Avalon was in court representing that
Yes.
they had support in place to help her. And that's a gap that needs to be addressed going forward. If Avalon's going to come to court like that and make representations that they're going to help people, they need to be prepared to have IDs for people. Community corrections is a necessary requisite of any type of release, as the court knows. I'm just disappointed. I really am.
Well, I'm also trying to figure out why they wouldn't have used her jail photo, which the sheriff would have had, the sheriff's department would have had, and community corrections would have had access to. So I was a little skeptical of it, but I'm also, like you, Mr. Granatra, I'm skeptical of where the process fell apart, but
Yeah, you're exactly right. She's the one who said that. Oh, you never said that. Yeah, we heard it. That's why I wanted to play this before that clip. Yeah, she still didn't test. She went to jail.
I also realized that within a few days of her release, she was hospitalized. And so that certainly, I don't think it's something that was a sudden onset, is what I'm considering. And that afterwards, and now she's here a few days after being released. So I'm taking that into account.
If I can add as well about Avalon, Your Honor.
Because what's going to end up happening is you're going to mess this up. But yeah, go ahead.
No.
Keep talking.
No, I did attempt to reach out to the peer manager and caseworker and this week. Once I got the bond violation report from Mr. Ganatra, because I as well was disappointed. I'm like, what's going on? They were on vacation during the holidays and there was no support staff available to continue that process.
Well, and they should have let people know that.
I
whole lot
don't
of folks.
disagree, Your Honor.
Probable cause conference will be adjourned January 25th, 2024, 9 a.m. Bond will continue. I want no more missed test. Thank you.
Thank you.
Is Fred out there? I haven't seen Fred. I paused it right on Jessica Blanche just for Fred. I haven't seen him in the chat though. Probably went to sleep.
Calls the case. The people.
All right, we stay in Simpson for a little bit. This next defendant, you'll find out. She comes in. She's been in front of Simpson a lot. Yeah, like I said, going through the vault, cleaning out my folder. So, yeah, we'll check this one out.
On behalf of Ms. Tiara Quinton, is approaching. Ms. Quinton, could you state your name for the record, please? Tiara Quinton.
Thank you.
So today is date and time set for probable cause conference. We're asking for an adjournment. Our conversation with the people indicate that they would like to see our client get into some type of treatment. So I want to see if we can connect her with Don Farms in jail.
Okay, so how much time are you going to need?
I was gonna say that I have I wrote a letter and I wasn't able to have it with me today, but basically it just says that it just says I'm in treatment and stuff in Livingston County through DHS, and I have signed up for services. I have a parenting class that it starts like this week. And I just got a car and a job. And the only reason why I didn't make it to court before was because I didn't have a car and I live in Lansing. And I just got everything set up to where I have services, and I've been doing services and seeing my kids twice a week and trying to do everything that I can do to get them back. And
Okay. What do you want to do, Mr. Kerr?
So, Your Honor, I know that the court will likely not make any movements in regards to that without any proof of this information. So if we could, I don't know what the shortest adjournment the court would allow for us, so that I can see how I could get that proof.
For you or for your client?
for my client, Judge.
Okay, then I'll do 1 week.
Okay.
All right. In that way, ma'am, what I'm going to do is I'm going to adjourn it out 1 week. I realize you're saying that some things are starting this week.
Well,
next
I
week.
have like services going and everything and set up.
Right. I just need some type of verification.
I can prove it all. I can.
Okay.
I have it
okay.
all.
I gotcha. But it has to get to me.
Okay.
Okay. So I'm going to adjourn it out 1 week. You'll be able to talk with counsel, get that information. They'll be able to confer with the prosecutor's office and we'll see what we can work out.
Will I be
Okay.
able to continue bond? So I can see my kids?
Well, your bond currently is at a 25 cash surety on one case, on the child abuse case, and that is because,
Your Honor. she
Yes.
did
Yes.
8/3/9/28.
I know, but I turned myself in.
She also failed to report to community corrections, which I think is the most important.
right.
I turned myself in. Oh.
Yeah, but you didn't come to court.
I know, but I didn't know that I had 2 different cases. I didn't know that they were separate.
What do you mean?
I didn't know that they were 2 separate cases. I thought that they were all being held on the same day when I had court the first time. So the reason why I missed it was because I wasn't aware that there was a second. I didn't know that they were 2 different. Like, I didn't know that there was 2 separate cases. Like, I'm honest to God, I didn't know.
Well, I have a September 28th that failed to appear. That's on the 15th underlying case.
That was because I didn't know that that was separate from the other court.
Right, but on that one, ma'am, once you were arraigned on that case, you were supposed to report to community corrections and did not do so.
Right, well, because I was supposed to go through the DHS, the drug tests and stuff, and they took a while to get me the services, like to get to the services, the mobile ones where they come to me because I didn't have a car. And so they took a while to get to everything set up, and like it was after that when I finally got that set up and everything squared away with that.
Okay,
But I have
That-
services
ma'am,
and testing and everything.
you were supposed to appear on the child abuse case on August 3rd, didn't appear. Then in the
Right.
other case, you were supposed to appear in September and you didn't appear.
Right, because I didn't know they were 2 separate ones. I wasn't,
Well, even if you had thought it was one, you should have been appearing. And you didn't go to community correction.
I'm not,
Is there something going on with the video or the chat? I've seen a couple comments where people are saying, I don't know, is my internet shady today? Could be on my end.
sure what that is.
Yeah, I know, because you didn't go.
Can I please get my bond so I can see my kids, please? Please, they're baby, please. I turned myself in on this. I'm not gonna miss another court. I swear on everything. I'm not gonna miss another court day. I will not miss. I sat through Christmas and New Year, please.
Well, hold on a second, because she was supposed to appear in September on the child abuse case on the 28th.
There was a typo in one of the emails that I had. It was like, I showed up an hour after. I showed up an hour late for one of those.
For one of my hearings?
Yes, it was, I showed up an hour late and I showed up at 1:20 instead of 12:20 or 12 o'clock or there was a typo in one of the emails there. It was not that I got from the public defender's office. I had showed up.
And then so this is all in September, so when did you turn yourself in?
I just turned myself in because I had to figure out everything with.
Oh, no, I didn't need to because. When did you turn yourself in?
In December.
So you waited?
Yes,
then to
I was
turn-
scared. I was scared.
Yeah, because you had tried to submit a bond request or a bench warrant recall, and that was denied, and you didn't bring yourself in.
Because I wanted to wait because I had to figure out everything with family court and I wanted
Ma'am?
to make sure I got everything squared away with my car and make sure that I could tell you and have everything that I could, like, that, so I could show up. So I could like do this the right way.
Ma'am, your best thing with me is show up, but
I
you
know.
waited 2 months.
But I know, but I showed up for September. I showed up for the September one an hour late, and I only waited 2 months so that way I could get everything squared away and get everything done. And I turned myself in, and I'm not trying to play you or make excuses, because there's no excuse. I should have been.
Yeah, there isn't an excuse, but you're giving me one.
No, I should have been there. You're right.
I know I'm
But
right. I'm always right.
I just wish you would please consider some leniency on me since I turned myself in. And
Ma'am, you turned yourself in 2 months late.
I know, but I had to wait to get everything squared away.
Okay.
I didn't have.
I get that. I hear you. However, understand something. You were ordered to community corrections for testing. You didn't go. You didn't even call to enroll. You did nothing. Then you didn't show up to court on either one of these cases. Even if you had 2 dates, as you're saying, which I don't see necessarily, but even if you had 2 dates, you didn't show up for either one of them. Then you don't show up. No, you don't show up. Try to get a warrant recalled online. That was denied by me. And then you wait 2 months to show up. So if you're just looking at that, what makes you think that if I let you go, you're going to show up? Nothing.
Because you have my word.
I had your word before. That did me no good.
Sir, please.
Mr. Carey, I'll adjourn it out 1 week. That's the best I'm going to do. You give me other information, maybe I'll consider, but I'm not reducing her bond at this point in time.
Your Honor, may I add one thing?
Go ahead, pile on.
The people really only think that release to inpatient treatment would be appropriate. I do not think that outpatient or other services are going to be enough or appropriate, given that she has a meth possession charge and a child abuse charge involving an infant ingesting meth. So I have really serious, grave concerns for defendant safety and the safety of her children. So I just wanted to put that on the record that if defense wants to look into some kind of inpatient treatment, I think that would be the only appropriate release.
I would do that.
January 11th, 2024, 9 a.m.
Thank you very much.
Motion for bond reduction is denied. Bond will continue in each of these. Thank you. I got recalled. Fell off.
All right. Yeah. She talked a lot. Now, I have seen it happen before, but maybe once or twice in the, I don't know, year and a half I've been watching court. And I've watched a lot of court, but I've always seen it, like I said, once or twice where a defendant actually talks the judge out of his decision. He changes his mind and they let him out. Doesn't really happen, but it has happened. I don't know. You just got to learn. You just got to know when to stop talking. Anyways, all right. Next clip. We're staying in Judge Simpson's court. This one is interesting. The attorneys are going back and forth. Judge is confused. It's a good one though. But I will say this again. I'm probably going to say it at the end of the stream too. Everything's been verified and confirmed. I am going to go live with Judge Slavin tomorrow night. So make sure you look for that link. I'm going to be making a post of it probably within a couple hours after the stream. But yeah, just look out for that. It's going to be fun. All right, next clip.
She was here the last time things went haywire. Okay, just checking. Oh, yes. Oh, what I said is you were here the last time things went haywire. Court does call the case of Dwayne Grand versus Rodney Lowe.
Ready, Your Honor. John Shrub appearing by Zoom.
Good morning, Your Honor, and go blue. Darrell and Fair on behalf of Rodney Logan, defendant.
You know, I'm a Terrapin, so you lose, but I'll forgive you today because the Big Ten took it all, so I'm good.
Absolutely, absolutely. I didn't get much sleep last night.
All right. Okay, gentlemen, where are we on this?
Your Honor, this is a case that Your Honor granted a judgment for possession back on October 29, 2021, which was appealed by the defendant to the circuit court. Judge Connors dismissed that appeal and affirmed the judgment. An application for leave to appeal Judge Connors' order was filed with the Michigan Court of Appeals and denied. An application for leave was then filed for the review of the Court of Appeals denial with the Michigan Supreme Court, and it was denied there on October 31 of 2023. The case arises out of a foreclosure of a mortgage on the property that foreclosed on September 12th of 2019. On March 10th of 2020, 2 days before the 6-month statutory redemption period would have run, Mr. Logan, as plaintiff, filed a complaint to quiet title against my client only, challenging the foreclosure process. He got an ex parte order extending the redemption period and ultimately had to amend his complaint because his claims were against the mortgage holder who foreclosed. The Court of Appeals dismissed that appeal and affirmed Judge Archie Brown in the circuit court, dismissing Mr. Logan's complaint to quiet title. In the interim, as the court will recall, this court has entered an escrow order on January 4th of 2002, requiring Mr. Logan to pay rent in the amount of $1,500 per month during the pendency of his appeals, which, according to information I've obtained from the court, he did continue to do from January of 2002 until November of this past year, 2023. He has remained in the premises during December, and according to my client, he did surrender the keys to him this morning at 8:15 a.m.
Does he mean to say 2022 instead of 2002? There's no way an appeal process for an eviction or was it an eviction? 20 years? I don't think so. He has to mean 2022.
That's where the case takes a shocking turn, Your Honor. My client, once he got the keys, and he's on Zoom, he's at this hearing, he went over to the home and found the home in a terrible mess, and that the entire furnace has been removed from the home, along with light fixtures and everything else. In this weather, Your Honor, my client is going to have to replace the furnace immediately if possible. But the damage to the home is substantial. We got an answer to our motion, which was filed at least 2 weeks ago or more, yesterday by email from the defendant and his attorney. The only defense asserted is that my client supposedly is going to make a profit of $150,000 or more or less on his purchase of the property during the statutory redemption period. Your Honor, he has been denied possession since March 12th of 2020, after the statutory redemption period would have run and after it was extended, and while all these appeals have been taken. we were asking for an order for eviction, but based on the surrender of the keys and the possession of my client, I don't believe an order for eviction is needed. But we do have more compelling reasons. Well, first of all, Your Honor, the amount that my
Bottom
client,
line, counsel, you want how much is in escrow?
$34,500.
You want the 34.5 that's in escrow.
as soon as possible, Your Honor, and based on the answer filed by the defendant that the property is supposedly worth $297,000, a rent of $1,500 per month at this point, Your Honor, is obviously a substantial bargain to the defendant who has stayed in there and has paid that amount up through, but not including the December or January.
No, that's not what happened. We found out what happened to the furnace when the defense attorney talks. Yeah, we find out. He just yeeted out of the house. You just made me laugh, though. You guys are talking about renting places. My landlord, this is a couple months ago, just came and knocked on my door to check to make sure I was still living here. She said that nobody has seen you in a couple weeks, so they thought that I abandoned the property. It's like, you could have just called. She came over here and knocked. It's like, yeah, no, I just don't really go anywhere.
I get you may have a complaint with that, but now he's gone.
He's now gone. Yeah.
Mr. Fair, what's your position on the 34,500? I think that's all that I've got left here.
Yeah, that's correct, Your Honor.
Your client, you would acknowledge, has surrendered possession of the premises.
Absolutely, Your Honor.
All right. So now what's your client's position on the 34.5?
Well, Judge, I think the plaintiff should be real happy that my client has appealed this issue, because at the time of the sheriff's sale, the value of the property with regards to the sheriff's sale was $145,000. If the plaintiff had taken possession of the property and attempted to sell it, he would have gotten about $145,000. But no, we went through this appellate process, and now the property's worth almost $300,000. I think he should be happy.
There's no furnace, there's no fixtures. I have no idea.
Oh, well, yeah.
Okay, I'm not here to necessarily make anybody happy. All I need to know, and all I am trying to figure out, is what's your position on the escrow?
Well, I think my client should be returned to escrow, Judge, because escrow is a function of the discretion of the court, number one. And number two, the court should look at the facts and circumstances of the case. Number one, the plaintiff never owned the property. Never. They never. It's not like he had this property, gave it to the defendant, and then the defendant, quote unquote, destroyed it. And we don't even know what the condition of the property is. I mean, I'm hearing this for the first time. But assuming my client, who owned the property, has every right to take whatever he wants from the property.
The furnace?
So that's why. So
are you really going to argue with me that he has the right to take the furnace?
Well, Your Honor, it's his property until he turns it over to the plaintiff. It's Judge. I would not be arguing this if the plaintiff had owned the property initially and then
yes, you would.
No, Judge. No, Judge. In all seriousness, absolutely. But up until that point, it is my client's property to do with as they will. I mean, that's a dichotomy. It is totally different circumstances. But having said that, Judge, we don't know what the value of the quote unquote furnace or any other damages that the plaintiff is claiming.
All right, real quick. This is what I think is going on. The guy who was living there, the defendant, his house got foreclosed on. He owned the house. And I think the bank foreclosed it and he appealed. So the appeal process has been going on for a year and a half. He's been paying whatever, like the mortgage of the house. I don't know if it's a mortgage. I don't know what the situation is, but he's been paying escrow for a year and a half. The defense is trying to ask for all that escrow back, because now when the house was originally foreclosed, and whoever the new owner is got the house. The house was worth, what'd they say? It was like 100,000, and now it's worth like 250,000. My numbers are going to be off, but that's their argument. And now that he moved out, he took the furnace that the guy who owned the house paid for. Yeah, I mean that I could see why Judge Simpson's like, who takes a furnace? But yeah, I would think that that's part of the house. I don't think that would be something you would take, but we'll find out what happens.
I don't know how he can claim damages if he's never been inside the property until today or yesterday. But having said that, we're still back to the issue of the $33,000 or $34,000 and the appreciation of the property.
I'm not going to deal with the appreciation of the property. Right now, what I'm going to deal with is trying to restore that property to what it should have been.
Okay.
I mean, and that's what I'm going to deal with.
Okay.
So, counsel, how soon will your client be able to prepare a list of damages and get estimates regarding the property?
Your Honor, at this point, I'm not sure that I don't know that information yet, Your Honor. But Your Honor, under the circumstances, the $1,500 was ordered by Your Honor under the court rule, providing that an escrow order shall enter during appeal, and the court ordered the defendant to pay a reasonable rent for the premises from the date the escrow order is entered. The fact that there's damages, Your Honor, is an entirely separate cause of action. The rent that was ordered to be paid, my client has lost the use of the premises. He could have rented it all this time.
But then I get into the argument of who had rightful possession during the course of the appeal, right?
But see, that argument of Mr. Fair is contradicted by the Court of Appeals. Well, Judge Archie Brown found that the defendant's complaint to quiet title was dismissed.
Folks,
The title has been, his client is not the owner. I mean, that argument has been appealed and dismissed, and your judgment has been appealed once and requested to be appealed twice. Everything is res judicata, Your Honor. They can't go back and argue anything. The only question is, what was the purpose of the rent escrow? And it was to pay rent, the fair market rental value. His client isn't the owner and hasn't been the owner of the property since the Court of Appeals dismissed his appeal. But really, since Judge Archie Brown determined that he didn't own the property, which goes back to 2019, Your Honor. So all we're asking for today and all that's before the court is disposition of the funds in escrow. And that's what I think.
I'm absolutely aware what's before me. I'm just trying to figure out why nobody wants to do what I'm asking them to do.
I do, Judge.
Because my problem is this. I certainly could just release it. Yes, it's rent. What would have been the reasonable rent for the period in time? Is it the 1,500 or is it not the 1,500?
Your Honor, just based on the evidence that the defendant has supplied, 1,500 for a house that's worth supposedly 300,000, ignoring the condition and the lack of a furnace.
I can't ignore it, counsel. I can't ignore that. You're saying he took the furnace out. I don't know if somebody's going to claim that the furnace was there. I have to make an assessment as to how to distribute this escrow. I realize you guys, one wants me to say, well, just give it back to him because the property's increased. The other wants to just say, well, it's rent and do that. We're going to do it my way. How soon can your client get estimates and make a statement to the court as to what they believe the condition of the property was at the time that I ordered escrow?
Dwayne, are you on? Mr.
Yeah, so the escrow was ordered because of the appeal process. The original owner, appealed the foreclosure, So that's why the escrow was put there. So during the appeal process, who actually owns it? The guy living there still own it? I don't know. I would think so until the appeal process was finished or not. I don't know.
Yes, I am. Can you hear me?
Yeah, I can hear you.
Well, and also I paid $40,000. I paid $39,000 in taxes over the last 4 years.
You know
That was
what?
paid by me.
You know what? I don't think I asked to hear from you. I just wanted.
Okay, well, you're all right.
Here's what I'm going to do.
All right.
No, forget it. Forget it. I've asked twice. So we're going to just do it my way. Give
1
me
month.
a date 45 days out.
March 5th at 9 a.m.
Matter will be adjourned to March 5th, 2024, 9 a.m. Maybe you guys could figure out what you want to do on this. In the interim, I want an estimate of the damages and a statement regarding the condition of the property. Thank you.
Thanks, Your Honor. Go Big Ten.
Yes, that's about as far as I'm going to go.
All right.
Thank you.
All right, we're going into the last clip. Now we're going over to Judge Bryant. We've spent enough time with Judge Simpson for the afternoon. Finished with Judge Bryant, and she's not happy. She's not happy for the last 15 minutes of this video. You'll see. All right. If you haven't hit that like button already, please do so. Let's go.
Your name for the court?
Shatonia Bentley.
Ms. Bentley, what time was your court hearing today?
It was at 8:30.
And what time is it now?
It's 9:30
Why are you late for court, Ms. Bentley?
because I work a midnight job and I didn't get off to 6:30 this morning.
Okay, that math doesn't add up to me. You got off at 6:30 and you had a court hearing at 8:30.
Yes, ma'am. I fell
What
asleep.
Logging in.
I fell asleep, and when I woke up, I had to re-download Zoom and get back in so that I could attend Zoom.
Wait, I tell you this. So start your camera. Let me be able to see your face. when I tell you this.
I keep trying to unsee it, but it won't. Okay, there it is.
Yeah, this one is old. As I said a few times, maybe I've always said it at the beginning, but I was going through my vault. So these are all clips from January. Yeah, because it's Sunday and not a lot of court on Sundays, so you got to go to your vault.
Number one, you in the bed and you attended to my court. Number two, you already said that you were sleeping. That's why you didn't come to court on time. Number three, the fact that you went to work is your problem, not mine. You had a court hearing at 9 o'clock. I mean, at 8:30. If you don't know, number one, how to get here on time, and number two, how to come correct when you do come, ma'am, don't come. Don't come. A warrant is just gonna issue for your arrest, and there's a place I can guarantee you that you're gonna log in. I won't have to worry about if you sleep. I don't have to worry about if you had to work, and that's from the Wayne County Jail. So, okay, that's all I have to say. She's an hour late. She's not apologetic about being an hour late. She's an hour late and in the bed. Now, I wonder if I wanted to stay in the bed, because I've been up since 2:30 this morning. And I'm thinking I wanted to stay in the bed too.
I'm not apologetic, Your Honor.
Don't worry, it's not a conversation. It was just me telling you that I'm gonna issue a warrant for your arrest if you show up again an hour late to my courtroom. Furthermore, you're going to get out of the bed. So I'm gonna send you to a breakout room. The attorneys are gonna assist you, and you're gonna get out of the bed. And
Okay,
not
no
come
problem.
back disrespectful. Please accept to join the breakout room.
Thank you so much, Mary, for all the gifted subs. Welcome to all the new members. Thank you. Very generous with the 20 gifted subs. Thank you so much. All right. I don't think I edited out this breakout room, so I might be fast forwarding it. Yeah. I know I didn't.
Mr. Bird, are you able to do, who I
Yeah,
believe is Mr. Dixon in the weight room, because he wouldn't turn on his camera and now he came back?
I am, Your Honor.
We'll just let it play. I don't remember what case this is, but we'll let it play. What is up, Iron
Please unmute and
Auditor?
state
Good to
your
see you,
name.
buddy.
Please unmute and state your name.
Barry Dixon.
Now, Mr. Dixon, why didn't you turn on your camera when I was ready to call your case and I asked you 3 times to turn on your camera?
No excuse. I never turned it off. My screen timeout must have took effect.
I guess it's still time for me to hear new stuff all the time. Because when your screen take effect, you just tap the button and then you push turn on your camera. Okay, I mean, yeah, let's go with that. Issue a warrant and I scheduled him for October.
Looks like I do skip ahead. We'll just let it.
March the 7th again.
Where am I going?
Have a
Where am
great
I
day
going?
and stay safe.
Try to find that last lady.
I need to set a show pause for.
There she is. She's back.
As they require either in person, 745608001, the people of the state of Michigan versus Shatanya Renee Bentley. The defendant is charged with assault or assault and battery. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of
Yes, Your Honor. Brandon Bird on behalf of Shatanya Bentley, my client, waives the right to the formal reading and will stand mute. Ms. Bentley, please unmute yourself and state your full name for the record.
Shatonia Bentley.
Please state your full name for the record.
Shatonia Bentley.
Please state your full name for the record.
Shatonia Renee Bentley.
Today is the date set for an arraignment on a bench warrant. Ms. Bentley is actually supposed to be under the court supervision for probation. And I'm looking at the first sheet of the register of action, and she has posted bond at least 4 or 5 times. That means she has capias on this case at least 5 times. She has failed to appear at least 5 times. Because had she appeared, she would have never even had to meet me. And I'm struggling with her having her hand under that chin, Mr. Bird. Now, I don't know what the conversation was in the breakout room, but what I'm struggling with is the casual nature that Ms. Bentley is appearing in my courtroom. That's what I'm struggling with. And what I know for sure is that if she was present in person, standing in front of me at that podium, I wouldn't have these issues about her being in the bed. I wouldn't have these issues about her having her hand up on her chin. None of that, because she would be standing in front of me at this podium the way it was prior to March of 2020. Now, the world has gone back to normal, or what they say is normal. And court is open. Court is open for business. In fact, there are 2 people sitting in my courtroom right now, waiting for their case to be heard. There could be 3. There could be 3. I'm not gonna be disrespected on this Zoom. My job is not gonna be minimized and casualized on Zoom. We are in court. We are in court. Court is in session. This is the session of the court. Okay, so she has failed to appear at least 5 times. It appears from the register of action that she was sentenced in 2018. In 2018, I think I was doing the felony docket for the auxiliary judge docket. What I know for sure is I wasn't doing this docket. And she was sentenced. She had to be, well, I'm sorry, she was scheduled for sentence. She had to be re-referred. Even before she was sentenced, she had to be re-referred for a pre-sentence investigation. That means she didn't show up. She was supposed to be discharged in May of 19. I didn't get on the docket until March of 2020. Since that time of her sentencing, she's KPS at least 4 times. At least 4 times she's failed to appear. Since she was sentenced and placed on probation by this court, she failed to appear at least 4 times. Okay. Mr. Byrd, what you want me to do?
Your Honor, respectfully, if we could set her for a review date. My client is here today. She did pay
I'm doing a review now. She didn't do anything. She failed to appear. She wanted to show up. That's the review.
Respectfully, Your Honor, my client did pay her bond fee and showed up on her own volition today. I do
$10. She paid $10 because that's how generous and merciful I am. She paid $10. Go ahead, I'm listening.
And we thank you for that, Your Honor. We do thank you for that. And actually $10 is a lot of money for my client. She indicates to us, even though she works, she still is struggling a little bit. What she does have left for probation, she indicated to me, was that she had to pay the payments, and unfortunately, she has been unable to pay. She has been trying to get herself together. She is working and does want to put this matter behind her. I believe that she understands that it's been years that went past, also, as this court sees. And it's not only a burden to this court, but it's also a burden on her, and a burden that she wants to get over. She could have just not shown up and not paid the $10 at all, which I'm not saying that would help the situation at all, but she did. She chose to try to put this matter behind her. She chose to try and come on her own. And
But it don't matter to me if she pays $10 or not, because I mean, it does a body good sometimes to get stopped at stop sign. Get stopped at, you go through the yellow light a little too late and you get stopped and then the police arrest you. So karma is something else. It comes back around. She could keep running and keep running. She could keep running until she can't run. And when she get caught at the most inconvenient time. So she could have just kept on running and waited till the most inconvenient time. But she was on her way to a graduation, a wedding, a big event, something, and then they arrest her. So that's what karma will do to you. So she didn't do me no favors by showing up. And she showed up like she's doing me a favor. Telling me about she had to take a nap. Telling me about how she overslept. Telling me about why she in the bed. Tell it like she doing me a favor. Miss Bentley isn't doing me any favor. I don't have a warrant for my arrest. I don't have a case pending. I did not plead guilty to assault and battery. I wasn't found guilty of assault and battery. So Ms. Bentley is coming on here like she's doing me a favor. We can end it now. She never has to deal with me again until she presents herself to jail. We could take care of it like right now. We could literally be done with this because Judge Archer gave her probation, which was the alternative to jail. And then she keep, showing up and going away and showing up as if that's, doing us a favor. It's not. We already gave her an opportunity to get the alternative to jail. Sometimes, people just need to go ahead and get it over with. It's a 93-day misdemeanor. Next thing you know, you look up, she done missed the whole winter. She don't have to deal with the rain, the snow, none of that. She don't have to deal, she don't have to shovel nothing. And by the time she get out of the Wayne County Jail, the spring is here. And now the flowers blooming. So we could do that. She picked a good time to turn herself in. Then when the snowstorm comes, she in jail. You don't have to worry about none of that. But what I'm not going to do is tolerate Miss Bentley coming here like she's doing me a favor, because she's not. And I'm not going to tolerate Miss Bentley coming on here like this some casual thing that we do. Because if it was casual, I wouldn't have wore a robe. I wouldn't have put on these pearls. I wouldn't have put on the dress that's underneath the robe. If it was casual, you see what I'm saying? I would have showed up just in my jeans, kicking it. None of this. I wouldn't have these flags behind me. None of that. I wouldn't have none of that because it would be casual. But every time I read the court rules, I don't read anything in there that says that my job is casual. When that young man left across that bench and tackled that judge the other day, nothing about that said that my job is casual.
I think every judge I watch has mentioned that clip since that happened. I'm kind of surprised how often judges watch other judges. That did go viral, though. I think everybody saw that. But yeah.
Everything about that said, even when you're dealing with a misdemeanor, your safety is at risk. That's what happened. So she needs to change her attitude, asking me for an extension for a review. No, the review is she has violated her probation. The review is she keeps not showing up. The review is she's ready to go to jail. But since she has such a great advocate, he just talks to me so nice all the time, even though your other client didn't do nothing. I just want you to know that other client didn't do nothing. But I'm never going to bring that into this new client situation. Because what's good for Miss Bentley is that I'm not going to treat Miss Bentley the way she treated me. I'm not going to treat her with such a casual way, the way she treated me. What's good for Miss Bentley is that despite all the times she has failed to show up, she has a judge that just literally believes in grace and mercy. Despite her failures and lack of respect for the authority of the court, I'm going to give her one more time, and I'm going to guarantee you this, that if I'm the judge, that if I'm breathing, that if I'm still on this bench, and she misses another anything, if she miss another review, if she miss another probation meeting with her probation officer, if she miss anything, I can guarantee you that Grace and Mercy gonna pack their bags, they gonna pack up their little overnight thing, and they gonna leave the room. They gonna say, we're not even here no more, because she taking us for granted. They gonna leave the relationship, because clearly it's a one-sided relationship that she's having with Grace and Mercy. And unlike some other places, in Judge Bryant's courtroom, Grace and Mercy, they do leave. They pack up, they take vacations, they go away, and they're not in the room when people keep missing court and keep asking for me to extend grace and mercy, and they put no skin in the game. And then come on here and treat me like I'm some little casual dating relationship. No, I'm not. And we ain't, no. I'm gonna refuse to be. I'm gonna refuse to be. And I want her to open up her eyes because I'm gonna accuse her of being asleep. And then I'm also gonna make her come in person. All right.
I love how all of you were asking if she was asleep, and then Judge Bryant said that. I knew it was coming. Oh, it was good. I'm glad you guys said that. I didn't notice it when I first watched it, that it looked like she was sleeping. That's funny.
Okay, I don't know if Mrs. Giatti remembers her, but it looked like the only thing she's been doing in 2023 is posting bonds and then not coming. So that's what it looked like she's just been doing. But I'm gonna give her 30 days to square up with Mrs. Giatti. Within this 30 days, she needs to see her probation officer. And just so that we're all clear, that $450 bond that she posted, as well as the $50 that she posted, as well as the other $10 that she posted, it's all been revoked. It's been mailed to the state and it cannot be applied because she keeps failing to appear. So if she had appeared when she paid that $450, it would have been applied to her fines, costs, and fees. We wouldn't have had to send it to the state after 6 months.
All right, everybody, it's that time. About 2 minutes left in the video. So I'm going to let it play out. Thank you all for being here. Thank you, Mary, for all the gifted subs. Very generous. Once again, welcome to all the new members. I will be doing a members-only video tomorrow. It's going to be earlier tomorrow, though, since tomorrow night got a special guest coming up on stream. So don't miss it. Yeah, I think that's about all I got to say. Yeah, that's it. If you haven't done it already, please hit the like button. Consider subscribing, and always do your jump kick backflips. Till next time, bye.
So we held it for 6 months waiting on her to come, and she didn't come. Okay. Let's give her May the 10th. And that's gonna be in person at 10:02, May 10th.
Yeah, I probably should have said that. 8:30 tomorrow. 8:30 tomorrow night, Judge Slavin will be on my live stream as a guest, watching a Sovereign Citizen video with me, reacting to it, and answering questions. That's tomorrow night at 8:30. After this stream is over, I will be working on the finishing touches of that and putting it up. Thank you, Mary, for asking that question. I probably should have been more specific.
In person at 10:02. That's in person, 36th District Court. And before that hearing, she is going to meet with Mrs. Giatti. She is going to find out if she ever did any anger management, community.
All right, I'm terrible at this. 8:30 Eastern time zone. That's what time zone I'm in. So Eastern time zone. So it is 2:30 my time right now. So 8:30 my time tomorrow. Live with Judge Slavin.
Service, victims impact panel. Why she have to do the victims impact panel? I don't know. She might have had a drinking problem. The order is what it is, and it didn't come from me. It came from our colleague and it's gonna stand. It's gonna stand. It's going to stand, okay? So she needs to find out from Ms. Ciotti what she needs to do, and then it'll be all right. May
Hector, that is the video I'm doing tomorrow for members only. Yeah, it's because of the nature of it. I don't want to. Yeah, I don't want to get in trouble from YouTube. So hopefully, members only will get around that.
in person at 10:02. Anything further? Do we have a current address and phone number?
I do, Your Honor, and I'll put it in the chat to the court.
All right, then we're all set. Ms. Bentley. Have a great day and stay safe.
Thank you, Your Honor.
Ms. Easton, Ms. Covers getting ready to have to come in person.
So